And good afternoon. Welcome to a very special edition here of Inside the Law today. We have a short 30 minutes with a very special guest. You probably all are familiar with her. She probably needs no introduction whatsoever, but we are joined by investigative reporter Julie Kelly, who is probably one of the foremost authorities on all of things related to the Donald Trump criminal cases, particularly with respect to what's happening in Florida and New York. And so I want to go ahead and please welcome to Inside the Law, Julie Kelly. Julie, how are you this afternoon? Welcome.
I'm great, Phil. Thank you so much for having me on and for doing this show routinely. I think we need a lot more information getting out to the public because it certainly is not being covered in a way that it should be. So thanks for having me on.
Well, for those of you who are looking for Julie online, you can find her. She's got an excellent Substack called Declassified with Julie Kelly. And of course, she's an investigative reporter. And I was looking, Julie, you obviously write for Real Clear Investigations. And I noticed this, one of your more recent pieces here regarding Judge Eileen Cannon. You call it Portrait of a Judge in the Fractured Double Reality of American Justice. Tell us what's going on with this piece, and then in a minute, we'll have you tell us what the latest is out of Florida.
So, Phil, my piece there just sort of gives a background on Judge Aileen Cannon, explains sort of updates where the classified documents, so-called classified documents trial is, the status of that case in Southern Florida, and really just sort of contradicting or debunking a lot of the media narrative about Judge Cannon. As you know, she is under fire relentlessly by the corporate media and so-called legal experts like Andrew Weissman and Barbara McQuaid and Glenn Kirshner and others who fancy themselves as legal experts and want her removed from the case simply because, Phil, she does not do what most federal judges, especially judges in Washington, do, which is act as nothing more than a rubber stamp for whatever the DOJ or special counsel Jack Smith wants. And some of this bad blood, as I explain in my piece, dates back to August of 2022, following the FBI armed raid of Mar-a-Lago, when Donald Trump filed a lawsuit seeking a special master, a third party, to go through the more than 13,000 pieces of evidence that were seized during that raid. Not trusting, understandably so, Donald Trump not trusting DOJ and the FBI to handle the investigation with any level of integrity. And Judge Cannon in September of 2022 did just that. She did appoint a special master. She did criticize the DOJ for leaking information to the media and mishandling privileged communications early in the investigation, and basically said that she believed a third party was necessary. She was overturned by the 11th Circuit, the appeals court there, saying she didn't have jurisdiction to do that. So now you see the drumbeat, constant drumbeat. The Judge Cannon is a novice. She's compromised because she's a Trump appointee and because she had been reversed by the appellate court. And they want her.
Let me hang on. I don't know any judge really who's been a judge for any length of time that's never been reversed. I mean, are we supposed to believe that? I mean, if all judges were perfect, we wouldn't need appeals courts, would we? I mean, what's the deal with that?
Well, exactly right. I mean, for example, if Judge Tanya Chutkan, and you see her photo there, who is presiding over the January 6th indictment by Jack Smith in Washington, D.C., she is the one who authored the landmark decision saying that presidents are indeed subject to criminal prosecution. They are not immune. That is the decision that will be before the Supreme Court. Oral arguments are set for April 25th. Now, what if the Supreme Court comes back and reverses Tanya Chutkan and says, no, there's no precedent, legal, constitutional, or otherwise, that suggests presidents can be subjected to criminal prosecution? Will then these same experts come back and demand that Judge Chutkan step down from that case? Judge Chutkan has already been reversed by the appellate court for sentencing decisions that she and other judges have made. So to your point, it is not uncommon to be reversed by the appellate court or even Supreme Court. As you know, Phil, Jack Smith himself was reversed unanimously by the Supreme Court in his conviction of Virginia Governor Bob McDonnell and his wife. So, only a certain set of circumstances apply to Judge Cannon because she is tough as nails, not just to DOJ, but also to the defense as well. And she is handling this case carefully and meticulously. And that is what the Andrew Weissmans of the world do not like.
Well, here you have this sentence out of this piece. Since being assigned to the case, Cannon has issued a series of decisions unfavorable to the DOJ. During a March 14th hearing, she pointedly forced the government to admit that no former president or vice president has ever been prosecuted under the Espionage Act, which, by the way, has no criminal penalties associated with it. But recently, she has also ruled against the Trump defense team. What was that ruling, and how is it? How does it fit into the state of play, if you will, for the case at large there in Florida?
So, more recently, Judge Cannon has denied two motions to dismiss the case. The first one was based on the unconstitutional vagueness of the Espionage Act. That defense motion she denied. She also has denied for now the defense motion to dismiss based on protections of the Presidential Records Act, which is emerging as sort of a conflict between the defense and the Department of Justice. Donald Trump and his co-defendants, or at least Donald Trump, arguing that he has had a right under the Presidential Records Act to determine which records were presidential versus personal. DOJ came back and said, no, he doesn't. And furthermore, the PRA has nothing to do with this case. Funny, because that's how the whole investigation originated. So she has been even-handed. But she also is extremely skeptical of the arguments made by Jack Smith and his prosecutors. I have been in the courthouse at least 3 times in the past few months. There's no video or audio access, so you have to go to Fort Pierce, Florida. You can either go in the courtroom or you can go into this overflow room where I sit to watch firsthand the proceedings take place. And she just seems very unfazed about the presence of Donald Trump or the presence of Jack Smith. She is very well regarded by her colleagues. I also link in my piece an article by Robert Draper at the New York Times, who spoke with current and former colleagues and classmates who had very complimentary things to say about her approach, her very cautious and unemotional approach to her cases. So this is what's being demonstrated here. But, there's any number of things that can happen from here on out. The May 20th trial date has been vacated, and they're trying to set a new trial date. But it's a complex case because of the nature of national defense information classified documents. And so I just wanted to give people who are unfamiliar with her or the case sort of a background. And that's what I did for Real Clear Investigations that you're showing there.
Yeah. So, how do you go about, if we have information that's, allegedly classified, how do you go about getting a jury that is allowed to see the actual evidence? Or I've heard it floated that maybe they won't get to see the evidence. So, can you help educate us on how that works?
Well, one thing that the corporate media and legal experts intentionally avoid is how this case is so complex due to the classified information included as evidence. And there is a statute called the Classified Information Procedures Act, SIPA, that has various stages built in that and safeguards from preventing people accused of harboring classified information from sharing that with them again for fear that they will do something with it. Now, this has never happened before, where SIPA is used to prevent a former president from seeing classified files that were produced during his administration under his purview that he had total authority over. So this is just another untested nature of this case in general. So the SIPA requirements involve a lot of closed door hearings, ex parte hearings, as you know, which only involve the judge and the prosecution. There has to be a secure location. The defense attorneys all had to get high level security clearance. There also needs to be a SCIF, a secure location, for the defense attorneys to view this evidence. But under SIPA, the government can heavily redact the papers or just give summaries of what these files are to defense attorneys and to the defendants themselves. Now, this is where Judge Cannon a few times in some of these matters has come back and said this information doesn't need to be redacted. I don't believe that this falls under these certain guidelines where you are allowed, the government is allowed to keep this from defendants and their attorneys. So this has been an ongoing struggle from the very beginning. So to your point, how are jurors going to be able to see these 32 papers that the government claims, Jack Smith claims Donald Trump stole and kept unlawfully? I think that's something that they're still going to have to iron out, whether it will be summaries, but I think it will be difficult. And I don't see Judge Cannon going along with any proposal where the jury won't be allowed to see in its full form, original form, these 32 papers that are represent the evidence against Donald Trump. But that is still, to my understanding, not been resolved yet.
Okay, so tell us what the discussions are and what the parties are trying to do with regard to a trial date. Because listen, I mean, I'm getting a lot. This is one of the biggest questions that I get. Is there going to be a trial other than, of course, what's about to maybe happen in New York? Are we going to get one of these other larger trials before the election? And I pretty much am of the mind that no, there's just no way possible that we're going to get any kind of a Donald Trump criminal trial before the election. And I'm not referring to the case in New York, the so-called hush money case, but with regard to the big federal cases, the one in Florida, the one in DC, and of course the Fulton County Fannie Willis, which I want to come back to in a minute because there's some discussion about whether there's coordination. But one of the questions that I'm getting is, how are we going to have some trials on any of these things? And I'm of the mind that no, there's just no way humanly possible between now and early November that any trial can get underway.
Well, there is a possibility that one or both of Jack Smith's criminal indictments against Donald Trump, this one in Florida and the other one in Washington, could go to trial before Election Day. In fact, Phil, I'll do you one better. If the Supreme Court comes back and they do rule, they agree with Judge Chutkan, and they do rule that a president can be criminally prosecuted related to his actions in office. If the Supreme Court comes back with that ruling at, say, the end of May, mid-June, it will give the green light then to restart the trial proceedings in Washington, D.C. Now, there's about a 3-month gap between the time that the trial was basically suspended in December of 2023 to the original trial date, March 4th. So there's like a 3-month timetable that has to be made up in terms of jury selection, questionnaires, and limine motions, all the things that happen pre-trial. Now, Judge Chutkan and Attorney General Merrick Garland have said that the election and politics has nothing to do with when this could go to trial. Judge Chutkan, I've been in her courtroom when she has said politics and the campaign plays no part in my courtroom. Merrick Garland said a few months ago that both of these cases are out of the hands of the DOJ. So Donald Trump, if the Supreme Court comes back and rules in favor of the government, there's the possibility he could be on trial in Washington, D.C. on Election Day for Jack Smith's 4-count indictment against Donald Trump.
Let's walk through that though, because it takes. We just had there's a massive RICO trial here in Atlanta involving a rapper known as Young Thug, another one of Fannie Willis's racketeering cases that she's brought in. It took them like over a year to pick a jury in that. And you've got obviously other things going on that are high profile, and there's nothing more high profile than these cases against the former president. So how I don't understand how you could conceivably pick a jury in addition to having, litigation on the um, soon to be filed, I'm sure, additional pretrial motions that could be coming from the defense in any of these cases that not only does the judge have to rule on, but of course appeals courts might have to rule on pre-trial. And I know that it's already, it's April. We're approaching the middle of April. The DOJ has a policy about not bringing these trials within a month or so of the election. So really, you've got, essentially a 6-month window of opportunity. And you've got other cases, obviously, that are on this dance card, so to speak. So I don't understand how you can really get all of the things done that would need to be done before we call jeopardy could attach, and a jury could be sworn, and witnesses could start testifying, and a trial could really be underway. It's very optimistic, sort of a scheduling agenda by Jack Smith. Has he indicated how he wants to maybe address any of those types of things if in fact he does convince the judge to try to start picking a jury?
Well, look, Jack Smith has had and will have his way in Judge Tanya Chutkan's courtroom. I mean, that's how she rolls, and that's exactly what she did before this trial was indefinitely postponed, awaiting the Supreme Court's definite answer on presidential immunity. But look, she will go right along with Jack Smith and the DOJ. She will fast track any in limine motions, witness list, jury selection. She will immediately deny any change of venue motion. She has already indicated that. I'm not sure what other motions could go to appeals aside from the immunity question that could further delay the trial. So Judge Chutkan will relish the opportunity to fast track all of this. And she will not care if Donald Trump is on trial. In fact, I think she and Jack Smith and the DOJ would love that, to have Donald Trump in a DC courtroom before a DC jury, as millions of Americans are going to vote in November. Now, back to your point about Southern Florida, what's happening with that case? There's now discussion between Judge Cannon, the defense, and Jack Smith's team about a new trial date. Jack Smith's team came back and asked for July. Judge Cannon said that was unrealistic. Donald Trump's team, of course, said, well, we prefer to wait till after the election, but if not, perhaps we could begin in August. So now she has already asked for draft jury instructions, signaling that she does plan to set another trial date. Now, if that trial date is set in August, and Judge Cannon will take her time, of course, with jury selection, carefully consider all in limine motions. She's already still got on her desk a motion to dismiss for selective vindictive prosecution. That could happen. But she could set an August trial date. Now, if that's the case, and this goes 6 to 8 weeks, it's then hard to see how Judge Chutkan could pull off, an October, early November start date. But look, anything can happen at this point. As you know, Phil, we've seen, we're already shocked at some of the revelations coming out of all of these cases, especially in Fulton County. So anything is possible. But I will say the Washington case, everyone there is chomping at the bit to get that going as soon as the Supreme Court renders its decision on immunity.
Well, I don't have a crystal ball, and I can't promise you that the sun's going to come up tomorrow. I believe it will, but we can't say for sure, especially on an eclipse day like today, right? We don't know what's going to happen. And maybe, maybe you're right. Maybe the judges can squeeze in a trial. I still am skeptical. I'm very skeptical that any trial can reasonably get underway, because these defense lawyers, if they're nothing, they are very, very creative, and they're obviously part of their plan is to run out the clock. That's just, I think, reasonable and good defense strategy. And so I'm very questionable. I just don't see that there's going to be a trial that can get underway. Maybe I'm wrong. Maybe you're right. But I know we got limited time with you, and you brought up Fulton County. And so I want to switch gears and talk about that just a little bit, because in your piece, you referenced that there might be some, looks like Trump's defense in Florida takes aim at coordination between the White House and Fani Willis. So that was what you wrote. And so I want to ask you about that. Do you think there's any evidence of that? Do you think we're going to hear anything new? Are we going to get answers on that point? What do you got on that?
So you'll recall when Fani Willis announced her RICO indictment against Donald Trump and his co-defendants, she was asked directly by a reporter if she had had any communication or collaborated with Jack Smith at all, and she declined to answer. Well, what defense attorneys and others have unearthed is, and this is defense attorneys in the classified documents case, they have filed a motion to compel, which means sort of, as you know, but others may not know, force the government DOJ to produce materials, evidence that they believe is either impeachable evidence for witnesses or the prosecution, or certainly exculpatory evidence. And what the defense attorneys laid out in a 68-page motion in January was describing the scope, what they believe is the scope of the prosecution team, not just Jack Smith and Jay Bratt and David Harbaugh, who are the top prosecutors, and a few FBI investigators, which is what Jack Smith argues. No, they argue that the full scope of the prosecution team involves Joe Biden's general counsel, his White House, the National Archives, high level authorities, officials at the DOJ, the FBI's counterintelligence unit, and also Fulton County. And how much, and they have communications, or they have evidence of communication between DOJ and Fulton County, I believe specifically Nathan Wade. Now we know that Nathan Wade also has Fani Willis did too, visited the Biden White House as before, or as this investigation was ongoing before the indictments. So it looks like there also was some collaboration with Fani Willis and Fulton County. Now, what this means for the documents, not so sure. But what they are presenting is sort of the opposite, is sort of a prosecutorial RICO case, which of course we've seen, Phil, for years out of this Department of Justice, collaborating with the intelligence community. That was another entity mentioned, and federal agencies to take down Donald Trump. And this was just another example. Now, Judge Cannon is still considering that motion to compel. And what really riled up the media and legal experts is that she indicated she wanted some of the communications that were now sealed and redacted. She wanted some of that evidence and said that it could be unredacted. So this is going to be probably a bigger battle and more explosive than, say, any of these motions to dismiss. And that is still on her desk. I don't know if she's going to hold a hearing on it. She's indicated that she might. But if she blows open the collaboration, or what we're told collusion, between the Biden White House, DOJ, and all these federal agencies to create or concoct this classified documents case, that is going to be severely damaging to the public image of Jack Smith's case in Florida.
Well, so this brings up another point, and this kind of dovetails with the senior chief has raised this question here. And if you've heard this, I want to hear what your thoughts might be. But this is, you asked what additional motions could be filed. I'm wondering if there's not a colorable claim of a selective prosecution when you have the contrasting sort of the documents cases between this one in Florida and, of course, the non-prosecution related to Joe Biden and his garage, where things going back to his days in the U.S. Senate apparently were laying around in the carport in the garage. So I'm wondering if there's not a reasonable claim to be made that that a judge might need to rule on. Is this something that's a selective kind of prosecution? Are you hearing anything about that?
So a selective motion to dismiss based on selective vindictive prosecution has been filed. It was emailed to Judge Cannon and the government in February. It has not been publicly docketed yet. I'm not sure why, but Jack Smith responded to this motion, even though it's not on the public docket. He responded shortly after it was emailed. But I will tell you, Phil, I was in the courthouse on March 14th to hear this evidentiary hearing on two of the other motions to dismiss that she has since denied. And this hearing took place 48 hours after former special counsel Robert Hur's public and congressional testimony explaining why, despite all the evidence that Joe Biden did the same, if not worse, really, truthfully worse than Donald Trump, because he wasn't president when he had all of these papers, including national defense files. And it was very clear. I called Robert Hur in his report the elephant in the room that day because Judge Cannon repeatedly raised it. She did so directly a few times and many times just sort of hinted at it. And it sounded to me like if there was anything she would dismiss this case on, it would be selective and vindictive prosecution. I have a piece up on my Substack from last month following that hearing. And I talk about the comments that she made in the courtroom, and she forced Jay Bratt to admit that no former president or vice president has ever been charged for espionage, violating the Espionage Act, or harboring classified papers. And she forced him to admit that a few times. And you could really sense, and all the other reporters could sense too, exactly what she was getting at. So hopefully she'll hold a hearing on that too. The next hearing is scheduled for the end of this month. It's on motions filed by his two co-defendants, Waltin Nada and Carlos de Oliveira. But I would suspect sometime in May, she will hold hearings on both this motion to compel for the prosecution team and certainly selective vindictive prosecution motion to dismiss.
Okay, and so if she were to grant that, for example, or deny that, either way, I mean, do you not see that there's any route for maybe some type of pretrial appeal on any of those things that it could sort of stop the clock from ticking on this request for a jury trial to get underway?
I don't know that they can appeal, that the government can appeal if she does grant a motion to dismiss the case. She probably could, or maybe she'll not the entire case, but at least the 32 charges that relate to violations of the Espionage Act. If she does dismiss those counts, and they certainly can appeal that decision, it would be pretty bold of her to do that, but I wouldn't be surprised just watching her conduct in court and also the motions that she filed. There was a big kerfuffle, as you know, last week. She had asked for draft jury instructions and told both sides to consider scenarios where the Presidential Records Act sort of acted as, a protection for Donald Trump or any president to declare records presidential or personal. And Jack Smith filed a really snarky, threatening motion, response to Judge Cannon, demanding that she issue an order on the draft jury instructions. Of course, as you know, she doesn't have to do that until well into the trial. And then suggested if she didn't do that, he would file a writ of mandamus asking the appellate court to direct her to tell her what to do. So this is really getting nasty. Not quickly. As I said, this dates back to almost 18 months, but there's really bad blood spilling out in public between the judge and Jack Smith in this particular case.
Well, listen, I appreciate you taking the time to come in here today, and I wish and to share this insight with us. And I wish we had more time. Unfortunately, we don't. But in the couple of minutes we've got left with you, what is it that we need to be watching with these things that you're following, so that we can maybe be in the know? What kind of what do you foresee on the horizon? What are the next big things, so to speak, in these cases that we need to be looking out for?
So, Phil, the big thing that I'm watching for this month is something that I've covered for almost 3 years, and that is the government's weaponization of obstruction of an official proceeding statute, 1512C2, which was passed in the wake of the Enron Arthur Andersen accounting scandal. And since the DOJ has weaponized that statute, used it to criminalize political dissent, charged more than 330 January 6 defendants with violating obstruction of an official proceeding. It was never intended to be used this way. As you know, it was a document evidence tampering, shredding statute that the DOJ has intentionally misinterpreted. And every federal judge in Washington, with the exception of one, Carl Nichols, has gone along with it. And so now oral arguments on the DOJ's use of 1512C2, oral arguments are next Tuesday, April 16th. I will be live tweeting at 10 o'clock those oral arguments. This issue, Phil, I would suggest is even more consequential than the oral arguments the following week, April 25th, having to do with the question of presidential immunity. If the Supreme Court comes back, which many people, even on the left, expect, they will reverse how DOJ and these federal judges have used 1512C2. That's even more damaging to Jack Smith because the 1512 represents 2 of the 4 counts in his criminal indictment against Donald Trump in Washington. So if the Supreme Court comes back the end of May, even before they render a decision on presidential immunity and basically strips 1512C2 from all of these prosecutions, including Jack Smith, what is Jack Smith going to do? Go to trial in October in Washington on 2 conspiracy counts against a former president?
No, he would appeal that. I think he would appeal it, but he's got to understand
he can't appeal the Supreme Court. He can't appeal the Supreme Court reversing it. He could come up with some new charges, but
he could try to go back to the grand jury, but what my point being, he's not going to take that. He's not going to just accept that if he's thrown out of court on that basis.
Well, what he would have to do then is file superseding indictment with more charges, which he could bring then seditious conspiracy charges and other counts, but that would then again delay that for certain until after the election. So this month, that's what I'm watching. 2 huge Supreme Court hearings. We will sort of get an idea based on oral arguments like we did in the Colorado Supreme Court case. We'll get some indication from those oral arguments where the court is heading on 1512C2 and also, of course, presidential immunity.
All right. Well, there you have it. Thank you so much for taking the time to come in here today, Julie. I really appreciate it. And we'll hope you come back and join us again soon, as soon as we have more to talk about. And by the way, speaking of appeals, I know that you're watching closely. I expect we're going to see some movement maybe any day now from the Court of Appeals here in Georgia related to the Fonnie Willis disqualification. So maybe when we get some breaking news on that, you can come back and chat.
I'd love to, Phil. Thanks so much for having me, and thanks everyone for tuning in. Hope to be on again soon.
You bet. All right, guys, there you have it. That's there's nobody following this in these cases more closely than Julie. I appreciate everybody coming in here today on this very last minute, sort of hastily arranged special edition of Inside the Law. But next time we'll see you here, and we hope to have a lot more information. Again, those are the things that we are following, but as any news breaks, of course, you can count on us trying to go back inside the law right here.